I want to let you know, like at any point during the presentation, it won't bother me, Joe, or Andrew for you to interrupt, raise your hand, whistle if you're like Susan, and ask a question. We're happy to try to give you the answer here today, and if we can't, we'll try to get an answer to you soon. With me today is Joe Reimer, who's also one of my partners at Phelps, and Andrew Olson, who's another partner at Phelps. They both practice in transactional law, primarily in real estate, and Joe more in business organizations, and then I am a board certified labor and employment lawyer. So I think in our introduction to you in writing about this presentation, we talked about the great migration to the great state of Texas. So how many of y'all are with companies that have moved like during the COVID era or just recently to the state of Texas? Do we have any newbies here? Oh, we need to get them to join because we know there's a lot of them. So we thought this would be an appropriate topic, not because things are modernizing just because people are moving to the state of Texas, but things are modernizing just because of everything that seems to be going on in Texas, in the US, globally. And so we wanted to address some of those issues here today. I'm going to start out primarily focusing on some just kind of high-level employment topics that we're seeing with this modern workplace that we all seem to be moving into either voluntarily or involuntarily. Joe Reimer's going to then talk to you about how the workspaces are changing, leases, and what folks are doing in terms of being green or whatever y'all call that in the real estate world. And then Andrew's going to talk to y'all about how the dynamics between different operations are changing within companies because of this modern work environment. So let me just start out with changing employee policies in the modern workplace. And I think, and this is my experience, I've been doing labor and employment law now for over 25 years, and I think what I see is causing a lot of these changes. One is talent, the need for talent, but the difficulty that a lot of companies are having in recruiting talent. And I just mean workers, whether they're skilled or unskilled, it's hard to recruit and it's hard to retain. The other thing, of course, is the pandemic. That changed tons of things in terms of the employment law world. And then the movement for more diversity, equality, and inclusion, that also has impacted a lot of the employment laws or the way employment laws are being interpreted today. And then finally, there's a lot, I will just say, as a labor and employment lawyer here in the state of Texas, I do not do a ton of labor work. Why? Because we don't have a lot of unions, but that is starting to change. And we're seeing a lot of information out there on social media that's really impacting and empowering workers to maybe go that route in the workplace. So let me just start out with a survey that was done by PricewaterhouseCoopers. And this is where they asked executives, hey, what are some of the things that you've done with your business in 2022? And more than half, about 75%, offered a hybrid. And I think part of that was because we were coming out of pandemic and a lot of them were offering a hybrid workspace. But a lot of them are electing to stay in a hybrid workspace. The other thing is they started increasing career advancement and opportunity. Over half of them increased compensation and are making plans to keep increasing compensation to keep talent. And then you see there's been also moving more to a remote work environment, improving benefits, changing processes, and so there's been a lot of changes going on in the workplace in 2022, and a lot of these companies, it wasn't just a temporary change that they made because of the pandemic. A lot of them are looking at them as they're here to stay. And so I want to talk to you all about the remote work environment and some of the legal issues that I already see popping up in the remote workspace. I'm going to pass over that. Oh, before I get into the legal issues, just some business considerations. I know all y'all are in-house, so you're not only looking at, for things from a legal standpoint, you're considering things from a business standpoint too. And obviously, when you have a remote workspace, there might be issues with communication, there might be issues with time zones, there might be issues with how you attract talent, cultural limitations, and then something that I've seen a lot, and I'm going to touch on just a little bit later, is the mental health issues that arise from limited socialization from a remote work environment. But the legal issues that I see, I think the primary thing that causes legal problems is, in the real estate world, location, location, location. Where are your employees working when they're working remotely? And I think a few years ago, before the pandemic, I presented to this group on multi-state employment issues, because at that time it was really strange. Like, a lot of clients didn't realize where your employee is physically is typically the employment law that's going to kick in for that employee. Some of those laws may depend on how many folks you have in that state, But a lot of the laws come into play simply because that person is working in that state. And what I'm talking about with those laws, and I don't want to get into it because I know I can talk to y'all about it for like an hour, is like leave laws. If you've got somebody up in New York City, for example, that's just working remotely, well, guess what? Paid sick leave kicks in there. Yet all of your other employees here in Texas, you don't have to pay them paid sick leave. So far, our legal system, our justice system has made that clear, okay? So paid sick leave, what are you doing about mini COBRA laws that might come into play? PTO, whether you pay that out at termination or not. How enforceable are your arbitration agreements or your non-compete agreements? You may have entered into those agreements when those employees were here living in Texas, and you had Texas counsel review those, and those were well written and enforceable. But now if that employee is working up in Oklahoma or Montana, perhaps that non-compete agreement is no longer enforceable up there. And I'm not just talking about the non-compete in terms of the locale of where they're working, but your non-solicitation agreements in those contracts may no longer be enforceable under those state laws. Same with your arbitration agreements. So it's really important to know where your employees are working and make a decision if you're okay with that, and then look into, okay, what employment laws apply. Also, you obviously have to be registered to now do business in that state where your employee is working, and you have to start paying those state withholdings, those income taxes, and those employer taxes that apply to that state. So in addition to location, the other thing to think about, the legal issues I see popping up with remote work, is remote work reimbursement. Not so much for my clients who their employees are in Texas, but in other states. So let me just back up. No federal law that requires reimbursement for things your employees spend for their workplace when it's remote, okay? However, if they're spending money on expenses and they're an hourly employee and those expenses are taking them below minimum wage, then you may have a federal employment issue. But what I'm talking about remote work is employees you have in states where there is an obligation to reimburse them for the reasonable, like, equipment and supplies that they need to do their work. Also, workplace injuries. You may have Texas workers' compensation insurance, but now you've got employees that are working over in Louisiana, or that have vacation homes or whatever in New Mexico or Colorado. If they get injured in the work site, which is their remote workplace, and it's a potential workers' comp claim, your Texas workers' compensation insurance may not cover that injury. So that's something to think about. And I mentioned OSHA up there because OSHA does not define the workplace as the physical office, plant, facility of the employer. It defines it as the place where the person is working. So it could be a remote work environment. And then finally, the other thing I see is a lot of us attorneys, when we were drafting employee handbooks back in the olden days, we defined workplace, we defined the work parking lot, we defined, what the facility was. And so a lot of the policies that you have, if that definition is really just the physical workplace, there may be an argument on the part of the employee that, oh, well, this policy didn't apply to me because I wasn't in the workplace. So I think you need to make it clear in your handbooks that workplace includes the remote workplace that the employee is allowed to work, just so you, for example, maybe your drug and alcohol policy, if you wanted to discipline for someone for being under the influence on a Zoom call, and doing some harm to the company, but the way your alcohol and drug policy is written, it defined workplace as the physical facility or plan or whatever, then you might have an issue in disciplining them. I mean, I would still, as an employment lawyer, say to discipline them, but you may then have a plaintiff's attorney trying to make that argument, or them making that argument in front of the TWC for unemployment or that sort of thing. So I personally believe, and obviously it depends on the business and it depends on the number of employees, but I think a simple, and it doesn't look very simple, I've got 9 boxes up here, but an agreement or at least a policy in place as to what the parameters are or what the guidelines are for working remotely is a good thing to have. And if you do it in the form of an agreement, I definitely think you need to make sure that you point out that it doesn't change their at-will status if that's the case, and that you give yourself the opportunity to, at your discretion, to revise the agreement. But I think the agreement needs to talk about, well, who's eligible and what is the workplace? Because what you don't want is someone who you think is hanging out in their condo in Dallas working for you to find out they have a lake house up in Oklahoma, and that's really where they're working, and Oklahoma laws kick in, okay? So if you had an agreement or a policy in place that says this is your remote work spot, that's a good way to protect yourself from such a situation. Also, a policy that talks about what equipment they can use. Do you want sensitive company information going through people's personal phones if they don't have the right security in place? Do you want them downloading it to their desktop just because it's an easier unit for them to use as opposed to using the company laptop? So you need to address those sorts of things. These are all issues that I think pre-pandemic, when we didn't have a lot of people working outside of our offices or outside of our physical space, these are a lot of issues that we didn't think of. And honestly, during the pandemic, a lot of us didn't have time. There were more pressing issues, but something perhaps that you could address in a remote work environment, within a remote work agreement or policy. The other few items are whether they're permitted to have visitors into their home. For example, an employee who interacts with vendors, can the vendor meet at their home if they need to meet in person? Or do you want to make an arrangement where they have to come up to the office, or put it on Starbucks, they have to go to Starbucks to meet or something, as opposed to coming into your home to meet, those sorts of things. And then, of course, requiring them to report injuries. And then especially for those employees that are working remotely, that are hourly, I think it's a good opportunity in these remote work policies to re-emphasize all those great wage and hour policies that you have in place about timekeeping, reporting, breaks, those sorts of things. So one of the things in the PricewaterhouseCoopers survey that I pulled up, the second item, I think that we saw that employers made changes to our employees' benefits, second to compensation. And what we're seeing is that a lot of employers are now, 92% that responded to this 2021 survey from the Society of Human Resource Management, said 92% said they expanded their mental health programs, their mental well-being programs. A lot of companies are offering mental health apps, mindfulness apps, those sorts of things. We even are seeing companies offering mental health days. And so I'm going to cover just a couple legal issues I see with that. 74% of employers, at least according to this SHRM survey, stated that they increased work-life opportunities, giving new leave options. 64% gave enhanced child care support. So these are all benefits that you can see a large population of the U.S., at least that responded to this survey, are offering to their employees. And in today's day and age, I think that employees don't just look at the rate of pay. They look at the whole package because they're educated on what other benefits might be out there. And so I'm just pointing this out to y'all as benefits, at least according to this survey, that we see being extended to employees. The last one was 83% started offering more financial well-being programs, like helping with debt management, helping employees secure emergency savings accounts, and those sorts of things. Other employee benefits are a more comfortable work environment, which Joe's going to touch on, flexibility, which we've already touched on in terms of place, but also flexibility in terms of time, and then telemedicine options. So the legal issues that, from these options, the ones that I see most of the legal issues pop up with are these wellness programs. I want to remind you that as a company, whether you have a third party helping with this wellness program, or that's something that's being handled in-house, or you're gathering information, the ADA, whether the person's disabled or not, the ADA and GINA, which is Genetic Information Non-Discrimination Act, the legal issue that they pose is that information that you obtain from these programs, if you are obtaining it, needs to be kept private, and it needs to be kept separate and apart from other documentation within the company. It can't be like in the employee's main personnel file, or if it's an electronic file, it has to be separate. We also, and this is kind of old news in the employment law world, because this was talked about a lot when a lot of these health plans and wellness programs were popping up like 10 years ago, where employers were extending benefits like prizes to employees, like if you sign up for this weight loss plan, or you sign up for this to stop smoking plan, you get these rewards. And those were challenged as being discriminatory. So just very broadly, as a reminder, if the program is purely participatory and you get the reward or the benefit just because you participate, no matter how well you do or not, then that's usually okay. But if the plan is contingent on some sort of outcome in terms of your health, like you lower your blood sugar levels this much, then that's when you're going to start running into problems with the plan. Other ADA and GINA concerns are just, you don't want to offer a program that's going to inquire into someone's disability or their genetic information. And then, I'm not a tax lawyer, so I don't want to give y'all guidance on this, but I'll just say there are some tax issues with these wellness plans if it's resulting in a deduction in how much they have to contribute, or they're getting some sort of a monetary award or compensation for it. So I talked about that one of the business things you need to think about with a remote work environment is mental health, is socialization. And even before the pandemic, I will tell you all that a lot of the ADA cases that I worked on, because I think they were more complex, dealt with mental health. And I believe the reason is that, mental health isn't something you can see. It's not like you can see that someone has a prosthesis, or you can see that someone is going through some sort of chemotherapy treatment or something like that. Mental health is often disguised, and a lot of times the person who's suffering from it doesn't even know they're suffering from it. And so it seems though in this modern workplace, with a lot of the attention just worldwide focusing on mental health, that we are getting a lot of requests from clients to counsel them on accommodations in the workplace. Not just physical disabilities, but mental health disabilities. And then I'm going to touch on also religious accommodations. As I said, this is very high level, but the one mental health issue that, and this is aside from an actual mental health issue, but a question that comes up a lot is, okay, COVID. If an employee comes to you because of the fear of COVID, is that something that I have to accommodate under the ADA? If the employee's anxiety is considered a disability, then you would have to accommodate it. If it's just like a general fear that I'm afraid of contracting COVID, I don't want to come back to the workplace, or I don't want to work in this unit, this department anymore, or I need some other sort of accommodation, then that probably is not a disability under the ADA that has to be accommodated. But then there's also, aside just from the anxiety that could be the disability, there are also a lot of underlying disabilities, like somebody who's immunocompromised and therefore COVID is causing them concern. So I touch on COVID, but as y'all know, accommodations for mental health go way beyond just someone being afraid of COVID. It can deal with depression, it can deal with personality disorder, anxiety, all sorts of things. And so what I just want to point out to you is, I think where employers trip up the most is whatever the issue is, not engaging in the interactive process with the employee and documenting that you're doing that. So when unfortunately, these questions probably don't come to y'all as in-house counsel. They're going to some frontline manager or supervisor who the person says something about their mental health and they just dismiss it. And so they need to understand that when that sort of issue comes up, that it's important for them to put them in touch with HR, or if it's a smaller company, with you or whoever handles that, and for the company to actually engage in the interactive process with the employee. Because in the cases that I see that are a little bit harder to defend, it's because this never happened. And this doesn't have to be some big, elaborate 2-hour meeting. It's getting an understanding of what their issue is. Why do they think it's necessary for them to have an accommodation? How long do they need it? Why do they think their job could be performed with this accommodation? Or what other accommodation could help them perform the job? And then talk about options, whether it be options as accommodations inside the office or in their remote workspace outside the office. Talk about those accommodations. But I think what you need to do is overall is to come into that meeting without a predetermined outcome. Like, this guy doesn't have a problem and this is the only accommodation we're offering, because I think that's where employers then tend to get tripped up on all this. How am I doing on time? Am I okay? I don't want to take all their time. So let me real quick touch on religious accommodations. And I want to touch on this real quick because I'll tell you all the EEOC is touching on it. In October, the EEOC issued an update on religious accommodations unique to COVID. But then after that, in January, the EEOC came out and they updated their formal policy on religious discrimination. And so this is a hot item. And the religion, I think it got a lot of, it got a lot of attention back for 9/11, and then it kind of went away for a while, and then it came back during COVID. But I think that it's here to stay. And one of the reasons I think it's here to stay is the whole diversity, equality, and inclusion. You know, that's not just race. And I'm going to touch on that in a little bit, but that includes religion as well. And so religious discrimination is getting a lot of attention. I just listened to an interview with the EEOC, the new EEOC chair, and she talked about how this is an issue that the EEOC is interested in. And so let me say this. With religious discrimination, I think the main point is the law and the EEOC, and I say the law and the EEOC because a lot of the guidance isn't necessarily the law. It encourages employers to take a very light touch on whether or not that employee's religious belief is a sincerely held belief. Just accept that in most cases it is. I don't think that's the discussion you want to get into with the employee in most cases. What mainly is to focus on is there an accommodation there? And if there isn't, then what's your undue hardship? And focus on that rather than challenging whether or not something is really someone's sincerely held religious belief. So I talk about diversity, equity, and inclusion in the workplace because I suspect a lot of y'all have those committees or programs or processes that you're now putting in place to address this. But what I want to point out to you is, one, I just talked about this, consider religion in that, because I'm telling y'all it's getting a lot of attention. And I think if you just tailor your diversity and inclusion efforts on race or gender, you're going to leave out a lot of other protected classes, like someone's religious belief or someone's nationality or someone's age. That's a protected class too. So you don't want to just be focusing on your diversity efforts on just one protected class and then forgetting about the others. I think that could lead way to some sort of discriminatory challenge. Make sure, this is something that I see often, is the right hand doesn't really know what the left hand's doing. Make sure that you as legal counsel are aware of whatever these committees are that are handling these issues, and that HR is aware of it too, so everybody can be on the same page. Be cautious about using metrics for the reason I just talked about. If you're just using metrics, you may be discriminating against another protected class. Look at like, okay, why have we as Phelps, why have we had imbalances in equality? And rather than following the lead on what other people are doing, address what the root cause was for you not having a diverse work environment or an inclusive work environment or equality or equity in the workplace. And then even turning back, I mean, you don't have to reinvent the wheel. Turning back to y'all's original, like the anti-discrimination, anti-harassment policies that are already in your handbooks and giving training on that, I think that's a great tool. And the whole thing with diversity, equity, and inclusion, it's something that a lot of employees out there are looking for. It's talked about a lot on social media, and it's a great way to help sell the company in that regard, because people want to be in that sort of an environment nowadays. So let me talk about unions in the workplace.
Why you and your friends should be unionizing. First of all, what is a union? So a union is when a group of workers come together to achieve common goals. They could range from anything from workplace safety, wages and benefits, pensions, the ability to telecommute or work remote, and a bunch of other stuff. If one worker goes up to the boss and demands certain things, the boss doesn't really have to listen to them. But if the entire company or all the workers come together and request and or demand what it is that they want, the boss is more likely to listen to them. And when you have a union, you actually have to negotiate or bargain over those things. And that's why they've existed, right? It's when workers come together to really organize and be able to fight for their rights. Why should young workers care about this? By unionizing your workplace, you're directly fighting economic injustice to support yourself and strengthen the middle class. So if you happen to be in New York, check out the downballot.org. You're going to have a lot of information regarding the upcoming election for individuals who are running on a pro-worker campaign.
So someone told me that you were thinking about joining your union, but you just need that little extra push. So I thought I would give you 10 reasons why you should join your union. Number 1 is better wages and working conditions, because who wouldn't want those? Number 2, access to an employment lawyer if you should need it. Number 3, a voice at work, because every worker deserves a say in what happens in their workplace. A right to strike. 5, representation in disciplinary procedures, if you need them. Number 6, really good information. Unionized workplaces are generally safer workplaces. Number 8 is political lobbying to improve your work life. An independent democracy that represents you. Number 10, you gonna do it? You gonna join? Come.
And so again, in Texas, it's not an issue that a lot of us have had to deal with. It's an issue that we needed to be aware of because of the NLRA, the National Labor Relations Act, applies not only to employers who have unionized workforce, but any employer in the United States of America. And what it says in Section 7 is that employees shall have the right to self-organization, to form or assist labor organizations to bargain collectively through representatives of their choosing, and to engage in concerted activities or going on, and shall have the right to refrain from these activities. And so that means the employee's protected rights under Section 7 are the right to unionize or not unionize, to bargain collectively through representatives of their choosing, and to engage in concerted efforts. And so what happens is, what is happening is that a lot of the workforce is hearing these TikTok videos and they're engaging in these discussions, and employers that aren't familiar with Section 7 rights are halting or stopping this sort of talk, and it can get you into a lot of trouble because it could be violating the NLRA, the National Labor Relations Act. So the chair or the general counsel of the NLRB recently posted guidance that an employer who requires mandatory attendance at a meeting in which anti-union speak is being conducted, that is a violation of the NLRA. And the reason is, again, Section 7 not only allows an employee the right to participate in it, but it allows the employee the right to refrain from participation. And so her argument, it's not law yet, the board hasn't approved it, but her argument is when you have a mandatory meeting, in other words, you require your employees to attend, and you start talking about anti-union rhetoric or whatever, or beliefs, or pushing them in that direction, that you could be violating the NLRA. She has even gone so far as to say, if you are having a meeting to discuss the terms and conditions like safety issues, that's totally fine. But if during the course of that meeting the topic turns to union, then you need to at that point halt the meeting and say to the employees, it's voluntary for you to stay for this discussion. You're not required to be here. You can have your own beliefs about this, and allow them to leave and understand that they won't be penalized, they won't be disciplined for doing that. So some some concerted activity that is protected, that employees can do, even if y'all don't have unions in your workplace, is work stoppages, refusal to work on voluntary call-in, honoring picket lines, filing grievances, protest of discrimination. And so I want you to be aware of that, because when that issue comes up, if you just automatically discipline, then you could be getting yourself into some trouble. Objections to harassment, refusing to cross picket lines, refusing to work in face of a dangerous working condition. These are all things that we have board opinions out there that say, and some of them, you know, the pendulum goes back and forth depending on the administration, the executive administration we're in. But these are all examples of things that could be protected activities. Things that aren't are things like disloyalty, revealing confidential information, and those sorts of things. Another push that we're seeing at the NLRB is it used to be that once you had enough majority interest in a union, you filed your petition and you had to wait to see if that petition would be you could have an election to recognize a representative of the union. That is something that also is being considered to go away with. In other words, if the company really doesn't have a good faith belief that there's not majority support, they can't challenge it. It's not in effect yet, but I'm just making you aware of this because we have a new general counsel that's under the Biden administration, and things are this pendulum's starting to swing the opposite way of what we saw during the Trump administration. So, let me go back. I'm going to pass the baton to Joe Reimer, and he's going to talk to you all about how physically things are changing in the workplace.
All right, so we've been kind of post-COVID, we've been going through this sort of ordeal, and Claudine talked about with unions, the pendulum swinging back and forth. With respect to office space, it's going to be really interesting to see if things have changed and will change for the good, or if this is a pendulum thing. And with respect to the hybrid work model in particular. But some of the things that we've seen and we've all gone through here in recent times have produced some trends. And I've noted them here, growing emphasis on employee preferences with respect to the workspace, increased demand for attractive amenities and flexibility in the space, whether that's private breakout rooms and just kind of more sort of let the employee figure out what they want to do with this space versus here's your office. From a location perspective, movement away from downtown core centers to less expensive, more times than not, and more spacious opportunities, whether it be in the suburbs or just outside of downtown. It's interesting, folks familiar with Knox Street in Dallas, there's a 12-story building that went up the Weirs Plaza, I think it's called. Beautiful building. I was on a tour of it recently with ULI. And there's a ton of shared space and awesome boardroom, bar, shared area that the tenants have to use whenever they want. There's a restaurant down at the bottom. The bartender, they basically have a bartender that works the bar upstairs, and it's just an amenity of the space. Very impressive. And then open space, as I mentioned before, collaboration with your coworkers. I think there's this push by employers to respond to this, right? I mean, we want to be responsive to our employees, try to keep employee morale up, and create good workspaces for them. But everybody is still trying to figure it out. Like, what's the best balance with hybrid? Some industries are more, prone to make that work than others. And during this time, we're seeing, all these challenges. The hiring market is very difficult, as Claudine mentioned, and the cost of losing employees is increasing likewise. Inflation, extreme increases in cost of construction, which is going to tie into our lease discussion here shortly. And then, restrictions in your current lease. And one of the things that it started with COVID, and in COVID it was more kind of, gosh, we need some rent relief. We need to figure out ways to, economically make this work. And as we've come out of COVID, it's more with respect to the workspace. We've got, this workforce of 100 people, let's say, and 50 of them really come into the office. We have twice as much space as we need. And we have a 10-year lease that we're in year 2 on. Like, we got to change this. We got to come up with some way to make this more economical for the company as a whole. And in doing that, can we come up with a way to be responsive to the employees? So specifically with respect to leases, one of the best lessons that came out of COVID, to me, in our experience, was you have to go to the landlord with a plan. You cannot go to the landlord and say, we're getting hammered, economy killed us, COVID killed us. The landlord's like, well, what are you going to do for me? There has to be some sort of a negotiation back and forth. And so, in that context, a lot of times we were getting into discussions about, okay, can we extend the term? Can we, try to balance or aggregate the rent over a longer period of time? That sort of thing. Now we're past that. We've kind of learned that the landlords really weren't all that forgiving or flexible through COVID, at least in our experience. I think in other areas outside of Texas, maybe they had better luck. But going forward, in the situation where you do have that long-term lease that you're in and you're looking at your space and saying this just isn't working, we have to come up with a different plan. What are our options? And then also prospectively, when we're leasing new space, what do we need, learning through COVID and through this process of the workspace kind of redefining itself a bit, what things do we need to be thinking about, maybe a little bit more in more detail than we did in the past? So with respect to the first item there, negotiating amendments to existing leases, landlords are, particularly in this market, in Texas, there is opportunities here because, particularly if your lease is, 3+ years old, 5 years old or more, the market has changed significantly, okay? So if you're in a situation where you have more space than you need substantially, turning that back to the landlord used to be, the landlord would never listen to you, okay? Today, that's a conversation they're willing to have because the rent that they're getting from you for that space is likely sub-market rent, right? And so is there a way that we can work through our lease? Can I agree to take less space or get the landlord to agree to let me take less space in exchange for extending my term, maybe putting, I'll build the demising wall, I'll pay for that to segregate off the spaces, and to really kind of think through those pressure points and those potential leverage points to where you can go to the landlord offering something, positive for the landlord. We're seeing that landlords are willing to talk these days. And I think a lot of that's just, it's economics. It's the market driving that. So be leery of that and to the extent there's opportunities, try to explore them because we're seeing clients have some success in that regard. And then, prospectively, I think through COVID, we really, there are a number of provisions in leases that we typically sort of glaze over. Assignability, the landlord has their standard provisions. You're always going to have to get their consent, and we sort of accept that. We'll say, okay, if we assign to an affiliate, little standard just comments that attorneys, knock back and forth and are fine. But I think we're needing to, in order to generate more flexibility for companies and for tenants rather, we need to start thinking more about assignability and sublease provisions in more detail and see if we can't negotiate with landlords more specific kind of thresholds that allow for assignability, that allow for subleasing. Can we build in credit rating thresholds for sublessee, that, hey, if we are able to attract a sublessee that its credit rating is on par with us, for example, that's not going to be a reason the landlord can oppose or refuse to consent to a sublease. Similarly with assignments. And then also related to that, buyouts and early termination clauses, these aren't novel concepts. These are things that have always been out there, but we really just typically don't emphasize them. They're not something that we're going to hang a lease up on or spend a terrible amount of time trying to negotiate, because frankly, when we're negotiating a lease on the front end, we're trying to get a deal done. We don't want to focus on the end of the deal and the deal going sour or negative potential outcomes. But it's something to be mindful of and to think about. And related to that also is, to the extent there may be a guarantee on a lease, trying to get the guarantee to burn off so that if and when we do get an assignment, we're not having to be tied up with the guarantee as well. And the landlord's typically not going to relieve us from that. So just some quick notes there. And then I wanted to talk about kind of an emerging issue here that really hasn't come to us in detail yet, but it's New York and Chicago in particular, California. You're starting to see this term green lease, a green lease. And what is a green lease? And the reality is there's nothing kind of unique to it that makes it a green lease. It's really the idea being that the space that you're leasing, that from really planning through construction and build out, that process has been guided by an environmentally conscious and environmentally minded standard. And the standards, there's really three main rating systems that are out there right now. LEED, I'm sure everybody has seen and has probably heard of. Green Globes is one that originated out of Canada and is now kind of being used from time to time. And then Energy Star, which obviously we probably see on our appliances more, but also applies in the context of commercial real estate and building construction and stuff like that. So the idea is that we're going to build these concepts into a lease. And we're going to have a building, and we're going to try to attract tenants that share this mindset. And from a regulatory perspective, as I mentioned, New York, Chicago, California, you're seeing regulations through building codes, through zoning ordinances, where specific environmental building products, for example, are required. In probably I'll say less aggressive jurisdictions, this is done through incentives, right? Well, instead of regulating it with mandates, we're going to try to move the market a little bit through incentives and attract, this type of construction or these type of buildings through incentive programs, tax abatements, rebates, stuff like that. So it's a very interesting thing. The ESG movement in corporate America, I feel like this may be causing it, has gained a lot of steam. And again, it'll be interesting to see how it plays out over time. But corporations and companies are feeling that pressure to be environmentally kind of out in front of the ESG movement and environmentally conscious, and for purposes of attracting workers, for example, and employee morale. So I think it's going to be interesting to see how strong that movement kind of as it plays out, how, particularly through maybe a down economy that's coming. A lot of those kind of preferences and things end up getting less attention, but I think it's on the move, and I think it's something we're going to see more and more of. And being able to say, yes, we have a green lease, we occupy this much space in this building that's a green building, is an important thing. So green leases generally, they seek to equitably align the financial and energy saving incentives of building owners and tenants. It's going to cost more, right, to have a building that meets the certifications. But from a tenant's perspective, your operating costs that are always flowing through to you in a lease, you're typically going to be less in an energy efficient building. So there's some incentives that align for the landlord and the tenant that oftentimes are either kind of disregarded by the landlord and are just pushed on. or aren't focused on. The green lease forms, there's kind of some different approaches from a documentation perspective. New York, what you're seeing there's a form that has been developed, and I'll grab the name of the company. New York's law up there, it's called the NYC's Greener Greater Building Plan, and a group that's associated with that has put out kind of a template guideline lease that's really, it's a lot of plug and play. I mean, there's not a form. The other approach is to address all this stuff on an addendum. And so it's a very kind of early on evolving area, and I'm sure we'll see sort of standard green lease forms establish or become more and more common. But one of the things, I try to give you a feel for kind of common terms that come up in these green leases that are different from your standard lease. Permitted use is a very standard term in every single lease, but in a green lease you'll see general office use, but it will have this additional language regarding in accordance with the landlord's certification standards, whether they're certified by STAR or something else. And you get into this discussion of, okay, well, geez, if I have to comply with that standard, and that standard 5 years from now, increases, becomes more difficult, or requires, additional capital to improve my space, am I kind of tied into a situation where I'm aiming at a moving target and I'm constantly having to update my space? We obviously, as a company, a tenant, you can't have that. So there's, what you're seeing is commercially reasonable qualifiers on all these sort of green space terms, so that the tenant is kind of protected. But again, it's an evolving area. I think it's going to be interesting to follow, something to kind of be on the lookout for and be mindful of as I think these things sort of migrate more to the center of the country from the coast. And I think with that, I will turn it over to Andrew.
Cool. Thanks. So, Claudine and Joe have talked about, the way space has changed in this modern workplace environment and the use of space, and Claudine about primarily the relationship between employers and employees. I wanted to talk about kind of the practical effects that all of this has had on the practice of law, from my perspective as an outside counsel, and also what I'm seeing from my clients and friends who work in-house. So I've got a quick question for the room. Since the onset of COVID, how many of you all have switched jobs, or have made a career move? Yeah, I have to include myself there as well. Made a move last July. It occurred to me, I ran into actually my law school career counselor. Sorry to call you out, Annie. I walked into her office about 15 years ago at LSU and said, I want to go practice in Dallas, and here I am, so thank you. But since the last time I ran into Annie, she also had moved jobs, and we hadn't seen each other since. And we're seeing a lot of movement in lawyers moving from firm to firm, in-house lawyers moving to firms, firm lawyers moving in-house, in-house lawyers moving to other in-house positions. It's an abnormal amount of turnover, and it's created some changes in the way I think that we all practice, and we'll discuss some of the implications of the same. So, so one thing that I have noticed, and this is a little bit anecdotal, but I received a call a few months ago from a client of mine saying, frustrated, just had a paralegal resign, had another paralegal resign a couple of months ago, and 2 attorneys before that in my department. We've got high volume of work that requires due diligence, had great stability before the pandemic, and now we're having a lot of trouble keeping people around. Basically, the pitch to me was, we're tired of training people up to do this work within our system. Our legal department's not big enough to have that institutional knowledge to pick up that work with the turnover we're seeing. Instead of keeping it in our legal department of 10 people, it might make sense to move it to your firm of 107, or actually like 600, or whatever we've got. 170 some transactional attorneys from my perspective. And so what we've seen is a lot of, and when I'll back up as well, the same week that happened, I was talking to a partner of mine down in Florida who's got a large home builder client, and he had the exact same call the exact same week from his client saying we're ready to move some of this work that a generation ago we took in-house and send it back out to law firms in this environment. The other trend that I've seen, or the other thing I've seen in my practice, is with all the movement of attorneys from place to place, you've got multiple law firms that end up representing clients on the same project. And the way I've seen it is, one example, I had one of the large law firms call me, and their real estate team had left and gone to another firm. There was a conflict at that firm for a specific project they would have used them on. They called me, and that work ended up coming to me. And that's not anything new. I mean, that's stuff that's happened, but I think that we are seeing it a little bit more as you see, more people moving around in this market. Kind of touched on this, that in-house teams are seeing high turnover. There's a great market for lawyers right now. People are retiring early. People are deciding to, go work somewhere else, or people have been hired in situations where they're hired and they never have gone into the office. They don't meet with people face to face. It results in just maybe less loyalty than there used to be. In my practice, I'm kind of seeing a little bit of what I refer to as a donut effect. I used to get calls from in-house attorneys when they had some very large project that required the resources of a law firm to get involved, or a very complicated issue that required the resources of a law firm to get involved. So it was sort of that, the very big deals that were coming my way. Now what I'm kind of seeing is a lot of, and I don't want to call it low-level due diligence work, because I think that work is as important as any work, in some cases more important, but I'm seeing a lot of that type of due diligence work coming to me. I'm seeing the in-house teams, performing kind of the middle ground, day-to-day operational aspects, and I'm also getting the calls on the very big, complicated matters. So as I've seen this, some considerations, particularly with work that's been traditionally handled in-house, it's now moving to us. Some things that, or some, not to call them hurdles, but sort of the way to handle that. One is with the client I referenced previously, they had a system that worked very well for them, and one of their concerns in sending basically all of their due diligence review out to outside counsel. They'll say outhouse counsel sometimes, but is their system works. They did not want me to reinvent the wheel. So what that's meant practically is me spending a lot of time with the team that I've built internally, really learning their processes, tweaking it in a couple of places, but not changing it. And that is, goes so far as form of internal emails that used to circulate internally, will now come from me. There's certain people in their operations teams that are used to getting emails on Wednesday afternoons that describe issues and underlying easements and properties they have under contract. They're now getting emails, from my team on Wednesday afternoons that they can read in more or less the same format they were getting previously from their own teams. Other concerns for us are obviously, when you're doing diligence work, a lot of that was originally brought in-house a generation ago because of cost concerns. So when it comes back to a firm, you have to make sure that you're staffing it in such a way that it's not getting billed at super high rates. You've got to have very good internal processes for junior associates to be doing at least the first cut, having ideally a mid-level associate that it then gets filtered up to, and then when there's significant issues that at the partner level there are, there's a clear path of communication so that issue is flagged, it's communicated to the client, and business moves forward efficiently. The other thing that's been interesting for me is the client I referenced, and not so much for my partners doing primarily home builder work in Florida, but the client I referenced is sending me national work. as an outside counsel, I have a heightened sensitivity to getting into unauthorized practice of law issues, and that's something I've had to work with them on because it does sometimes slow things down when I say, I'm looking at this project in Pennsylvania, I see what is a legal issue. I'm not licensed in Pennsylvania. I need to consult with somebody in Pennsylvania to make sure that I am addressing this issue appropriately and that you're being represented. And I think that can create, specifically when it creates a delay, it can be a little bit hard for in-house counsel to understand it, because that's just a concern that when they're, when you're in-house and you represent your banner that you work for, you don't have the same concerns under most states rules of professional conduct. Address that with a very good long list of local counsel in all states. So, and then the second example of where the second example I cited that I've seen some change is multiple firms representing clients on the same project, and this, I think, from both the perspective of outside counsel and in-house counsel, if you find yourself in this situation, the lines always seem to blur more than, it's easy to say, you guys are going to do real estate, you guys are going to do debt documents, our engagement letters will contemplate that respectively, but those lines always blur, and it's really a matter of communication. It's certainly reasonable from the perspective of corporate counsel, in-house counsel, to assume and expect that the two firms that are working on their deals are in communication with each other and making sure that nothing's falling through the cracks. But it's easy. It's easy if I've been engaged to do real estate work, if I get sent a deed of trust or a intercreditor agreement that I'm asked to address and make comments for a specific real estate issue or to cover a specific real estate risk. It's easy to look at that kind of myopically and not make other comments, assuming that the other firm that is handling the debt documents is covering those issues, but that's really not something that you should assume. There should always be those lines of communication. Did you look at this? Did you cover this? Making sure that all issues are appropriately being addressed. Also making sure that there's good written communication as to, I looked at this, this, and this, but I did not review this. If you need me to look at this, let me know. And generally staying away from making assumptions that can get us all into trouble or cause a risk to not be addressed.